Okay, good morning. Can you all hear me? Yes. Okay,
Yes.
sorry about that, everyone. We're having some technical difficulties over here, but we're gonna go ahead and get started. Let me back up a couple of slides. So my name is Amy Newton. I'm an Assistant General Counsel with the Board of Regents Office of Legal Counsel. I sit over at OSU CHS. I've been working there since 2018. I've been working on GME related issues since about 2020. We thought this would be a good topic today because medical residency is kind of a unique time that's somewhere in between being a student and being a fully board certified position. And these are just, some good stuff, good topics to have in the back of your pocket as a professional anyway. This is going to be a pretty broad overview. I'd say each of these concepts could probably make up its own presentation. So we're really not going to be able to get into a ton of detail, but definitely happy to answer any questions. In the format we have today, I don't know that I would see them pop up in the chat, but if you chime in, I should be able to hear you. And at the end, we will have time for some questions as well. So here's kind of my usual list of disclaimers. This isn't legal advice for any specific situation you're going to find yourself in potentially. Specific situations are always very fact dependent. So you should reach out to your legal or your HR with any questions about anything that's may happen to you. I don't want to get calls from your HR offices saying I told you to do anything. That's not what this presentation is about. I also want to point out that we're mainly going to go over federal laws. These laws don't always apply to tribes the same way that they do to other entities, since tribes are sovereign nations. States, the state of Oklahoma and tribes also have very similar laws in many of these areas that work in a very similar way. So the concepts are still instructive. Here's our basic agenda. We're going to quickly define graduate medical education. We're going to set the scene for how resident physicians are treated in the employment context. We're going to go over several employment law concepts, statutory schemes. And if we have time at the end, we're going to walk through how these statutory schemes interact with accreditation guidelines and how they shape policies at the workplace level. I know you guys all know this, but just to set the scene, what is graduate medical education? From the ACGME Common Program requirements, it is defined as graduate medical education occurs in clinical settings that establish the foundation for practice-based and lifelong learning. The professional development of the physician, begun in medical school, continues through faculty modeling of the effacement of self-interest in a humanistic environment that emphasizes joy and curiosity, problem solving, academic rigor, and discovery. This transformation is often physically, emotionally, and intellectually demanding and occurs in a variety of clinical learning environments committed to graduate medical education and the well-being of patients, residents, fellows, faculty members, students, and all members of the healthcare team. So it's clear that residents are still in a learning environment, which leads to the question, how does the law view residents? Are they students? Are they employees? Are they somewhere in the middle? A 2010 Supreme Court case answers this question, and it uses federal taxation. It's kind of the vehicle to do this. The question specifically considered by this case was whether doctors who serve as medical residents are properly viewed as students whose service Congress has exempted from FICA taxes. Basically, this came up because Congress had exempted students from federal taxation when that student also worked for the school, such as in a work-study environment. Following the passage of that rule, the Treasury Department was flooded with claims seeking a refund of FICA taxes that resident physicians had paid. These claims were asserting that the residents qualified for the exemption as well because resident physicians were in a learning program affiliated with the university and their paid work was incident to the learning program. The Treasury Department decided it needed to clarify Congress's rule on the student exemption, more clearly defining who a student was, particularly for those individuals like resident physicians who performed on-the-job training. The Treasury Department adopted an amended rule stating an employee's service is incident to his studies only when the educational aspect of the relationship between the employer and the employee, as compared to the service aspect of the relationship, is predominant. Basically, that the learning aspects were a higher priority. So here are some examples, and I just want you to think where you think these might fall on that sliding scale of, employment versus education, and where these might fall. So there's an employee who works for an institution of higher education, but he goes back to school while working to obtain a degree. There's an undergraduate in a work study. What about a graduate assistant obtaining a graduate degree who has a, assistantship that is paid? Or, resident physicians, what we're talking about today. So the rule that the Treasury Department adopted does acknowledge areas where the services performed may have an educational or training aspect. The specific example they used for this is of the medical resident, which leads us to know that the Treasury Department did want residents to be included as employees and not as students. Therefore, the rule would make resident physicians subject to FICA taxation. The Mayo Foundation for Medical Education and Research, the Mayo Clinic, and the University of Minnesota, who the Mayo Clinic was affiliated with for GME, and we'll just refer to these parties as Mayo, filed suit asserting that the rule that the Treasury Department promulgated was invalid and sought a refund of the money it had withheld and paid on resident stipends. So this case worked its way through the lower courts and ended up at the Supreme Court. The court employed the Chevron method to decide the case, which used to be a test the courts used to determine if agency rulemaking was proper. So this method isn't used anymore, as the constitutional law scholars in the audience will know, but this Mayo case is still good law. The Supreme Court sided with the Treasury Department and upheld the rule. The court closed with this: "We do not doubt that Mayo's residents are engaged in a valuable educational pursuit or that they are students of their craft. The question whether they are students for purposes of Section 3121, however, is a different matter. Because it is one to which Congress has not directly spoken, and because the Treasury Department's rule is reasonable construction of what Congress has said, the judgment of the Court of Appeals must be affirmed. Therefore, under the law, resident physicians are considered to be employees, not students." Which leads us into the main thing we are going to talk about today. So these are some common employment law areas that you'll see most often. There are, of course, many others, but remember, we're just kind of hitting the highlights today. Starting with the Title VII of the Civil Rights Act of 1964. So prior to the passage of this federal law, there wasn't a good mechanism to prevent discrimination in the workplace. During the civil rights movement in the 60s, there was a push to pass a law to prevent discrimination based on race and some other attributes, as we'll see, in the workplace. A covered employer violates Title VII if they fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin, or to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. There have been some updates since 1964, but really the bones of the act remain largely the same. One update is that the definition of sex has been changed not to just mean biological sex, but to incorporate pregnancy, sexual orientation, and gender identity, or all of the things related to someone's sex. Title VII prohibits several different types of discrimination. Disparate treatment is intentional discrimination on the basis of a protected class. And remember, our protected classes are race, color, religion, sex, or national origin. Plaintiffs must show that they are a member of that protected class, they are qualified for the job, they suffered an adverse employment action such as not being hired, being fired, being demoted, getting a pay cut, something of that nature, or have some other evidence of discrimination against them in the workplace. The employer must then show that there was a legitimate non-discriminatory reason for the adverse action taken against the employee not related to their protected class. To prove a disparate impact, which occurs when an employer's policies, practices, rules, or other systems appear to be neutral, result in a disproportionate negative effect on a protected group, the plaintiff must show that the employer's practices exclude or otherwise discriminate against employees or prospective employees on the grounds of a protected class and are unrelated to job performance or are not justified by business necessity. Even if the employer can defend against the above allegations, the plaintiff can prevail by showing the challenge practice could be served by an alternative practice with a less discriminatory effect. Harassment is also prohibited by the Act. The conduct included in harassment can be verbal harassment, such as derogatory comments or slurs, physical harassment, assault, impeding or blocking movements, physical interference with normal work. There can be visual forms of harassment, such as posters, cartoons, drawings. Harassers can be pretty much anybody in the workplace. They can be supervisors, an agent of the employer, coworkers, or non-employees even that the employer has allowed into the workplace. The victim can be anyone affected by the offensive conduct. It doesn't have to be the specific person being harassed or the target of the harassment. Sexual harassment is also prohibited by Title VII. So sexual harassment is basically quid pro quo harassment or sexual favors becoming a condition of keeping your job. So an element of some of the above claims includes that there must be a hostile work environment. That's a defined term in Title VII, and it's pretty specific. For there to be a hostile work environment, the employee must show they belong to one of the protected classes, they suffered unwelcome harassment, that the harassment was based on their protected class, and it was so severe or pervasive that it altered some part of their employment, creating an abusive work requirement or environment. How can we tell if harassment was severe or pervasive enough? Is generally a consideration of several factors, including the frequency of the conduct, the severity of it, the physicality of it. Does it unreasonably interfere with someone's work performance? And this is both a subjective and an objective standard. Does the actual person being harassed feel that it is severe and pervasive? And there's also what we call the objective standard, which is the reasonable person standard. Would a reasonable person have felt in this person's position that this was severe or pervasive? You need both to show a severe or pervasive requirement. So retaliation against an employee is also prohibited by Title VII. But again, this is a pretty misunderstood and misused term. We'll see through most of these civil rights acts that retaliation is prohibited by them for participation in the specific act for whatever, class of discrimination that it protects against. So retaliation under Title VII is when an employer takes a material adverse action because an applicant or employee engaged in a protected activity. And that's it. A protected activity is either participating in an equal employment opportunity process, which are filing complaint of discrimination with the EEOC, or reasonably opposing conduct made unlawful by EEOC enforced law. Remember, these things are based on protected classes of persons. So if you think your employer is taking an adverse action against you, but it has nothing to do with being in a protected class or engaging in a protected process, it isn't retaliation under Title VII, and your recourse isn't through Title VII. To prove retaliation did in fact occur, the employee has to show that they, 1, engaged in a protected activity, 2, that the employer took a materially adverse action against them, and 3, that the retaliation caused the employer's action, or there wasn't another source of the action. This is called but-for causation. So, but for this, that wouldn't have happened. In this area, record keeping is very important to show timelines, other disciplinary issues, etc. Moving on to the Equal Pay Act of 1963. This is a part of the Fair Labor Standards Act, which was enacted with the goals of improving working conditions by establishing minimum wages, overtime pay, and child labor standards, which reduced exploitation and unsafe working conditions. The Equal Pay Act portion seeks to ensure that there is not discrepancy in pay between sexes. To succeed on a complaint, the complainant needs to show that they were performing work which was substantially equal to that of the employees of another gender, considering the skill, effort, and responsibility of the job. That the work was performed under similar working conditions within the same establishment. And 3, that employees of another gender were paid more under these circumstances than the complainant. If the complainant does this, the employer has the burden of showing the pay discrepancy is based on either a seniority system, a merit system, a system measuring earnings through quality or quantity measures, or another factor not based on sex. So what if the pay discrepancy is used to another protected class apart from sex, such as race? Remember, those protected classes are race, color, religion, and national origin. These claims are handled by the EEOC under Title VII. There's a burden shifting test shown here on the slide that goes back and forth between the complainant and the employee and the employer when there is an allegation of pay discrimination under Title VII. Okay, so Title IX is a federal civil rights law that prohibits sex discrimination in education programs and activities that receive federal funding. Although Title VII already existed and prohibited sex discrimination in employment, there were still some gaps in the educational context. It wasn't until the 90s that it was made clear that Title IX prohibited sexual harassment and sexual assault because those things are a barrier to educational access when they happen in an educational program. Educational programs have a duty to address complaints of sexual discrimination they receive, or their federal funding may be put at risk. Plaintiffs also have a private right of action against institutions if they believe their complaints were not properly addressed. So Title IX has expanded and changed throughout the years, through different regulations passed, different administrations, and through agency guidance. A new version was passed in 2024. It was subject to several injunctions, and as of last Friday, it was struck down nationally by a federal court. So we are still using the 2020 regulations in effect. So here's the question: why are we talking about this if it applies to colleges? Didn't we already establish that residents are employees and are not students? Well, the definitions in Title IX are a little bit different. So Title IX isn't limited to students, but it affects all educational programs who receive federal funding. In particular, in the preamble language in the 2020 rules, the Department of Education included some specific discussion about residency programs. Note here, the Department of Education used the term academic medical center specifically, but they don't define that term anywhere in the regulation. There is some limited case law about the applicability of Title IX to all residency programs, even those that may not be a part of an academic medical center. So note that these are not cases from the 10th Circuit, which is the circuit that Oklahoma is in. So these aren't binding, but they may be instructive to the courts if this issue is ever raised in the 10th Circuit. So the first case is a case from the 3rd Circuit, which held that a program that requires a resident to learn and train under faculty members and physicians, attend lectures, and help present Case presentations under supervision. In this case, participate in a physics class on a university campus and sit for annual examinations was subject to Title IX. Had the resident completed Mercy's program, she would have been eligible to take the American Board of Radiology certification examination. So Doe, the plaintiff here, also says that Mercy held out its residency programs as educational in nature and that the ACGME calls residency programs structured educational experiences. The court held that operating an ACGME accredited residency program is subject to Title IX because its mission, at least in part, is educational. The second is a case from Federal District Court in the District of Connecticut involving Yale University, Yale New Haven Hospital, and a program director. In this case, female residents at Yale New Haven Hospital, the teaching hospital for Yale University, brought claims for discrimination and retaliation under both Title IX and Title VII. The court found that the residents had sufficiently alleged that the hospital was an educational program or activity and were therefore able to bring Title IX claims against the hospital. The court used several factors in this determination: structure of the program, including the involvement of instructors and inclusion of examinations or formal evaluations, whether tuition's required, the benefits conferred through the program, such as degrees, diplomas, or other certifications, the primary purpose of the program, and whether regulators accredited the institution hold it out as educational in nature. So they weighed these factors and they held that the Title IX claims could proceed. They also held that the Title VII claims could proceed. And as you remember, Title VII claims are specific to employees. So in some circuits, you will see this. One does not necessarily preclude the other. And that is true in the 10th Circuit. We can have both Title IX and Title VII claims at the same time. Next is the Americans with Disability Act, or the ADA. It's a federal civil rights law that prohibits discrimination against persons with disabilities in everyday activities. Basically, the goal of the ADA is to make sure that people with disabilities have access to the same opportunities as people without disabilities. Employers, state and local governments, businesses that are open to the public, commercial facilities, transportation providers, and telecommunication companies all have to follow requirements of the ADA. So Title I of the ADA is specifically the employment portion we're going to be talking about today. It prohibits employers from discriminating against a qualified individual on the basis of a disability in regard to job application procedures, hiring, advancement, discharge, compensation, job training, and other terms, conditions, and privileges of employment. A disability is defined as a mental or physical impairment that substantially limits a major life activity. Major life activities include, but are not necessarily limited to, caring for oneself, seeing, hearing, walking, working, or operation of major bodily functions. What can be considered a disability is very broad, and there is not a specific list. There are more things that are not disabilities, such as pregnancy. You can have conditions related to pregnancy that are disability, but pregnancy itself is not considered a disability. The term, so somebody will qualify for protections under the ADA if they are a qualified individual, which is someone who can perform essential functions of a position either with or without reasonable accommodations. How do we know what essential job functions are? They are the job functions considered fundamental to a job and can be determined usually by considering what the employer thinks they are, which is given a certain amount of weight, what is in the written job description for that position, the amount of time spent performing that certain function, consequences to the organization or others if that function is not performed. Another exception from ADA protections are employees engaged in illegal drug use. They are not considered qualified individuals under the ADA. What is a reasonable accommodation? It is a modification or adjustment to a job the work environment, or the hiring process that will allow the employee to perform essential job functions. So these are highly fact-specific to each employee and each accommodation request. Some examples of reasonable accommodations may include, depending on the specific situation, physical changes such as installing a ramp, modifying a layout of a workspace, accessible and assistive technology such as screen readers, accessible communication such as sign language interpreters, adjusting work schedules, allowing extra time for certain tasks. An employer must make reasonable accommodations unless it would impose an undue hardship on the operation of the business. To determine if an accommodation would impose an undue hardship, several factors are weighed, such as the nature and cost of an accommodation, the financial resources of the facility, and the effect on overall resources and impact on the facility and other factors. So the bar is fairly high on employers here. Do we have to grant this accommodation the employee asks for? Not necessarily. The employee and employer have to engage in an interactive process to determine what accommodation will be reasonable, if any. Do not assume you can't accommodate something before engaging in this process. This is generally taken on by HR departments who go back and forth with the employee, and your workplaces should have a policy on this to delineate who has this responsibility. Employers can require a medical exam to ensure that the employee can still perform the essential functions of their job. This isn't necessary for many jobs, but for specialized jobs where not performing will put people at risk, it's an option. Again, HR often helps make those calls. One situation we see is there may be an employee who has a disability, and that disability is causing some misconduct in the workplace. Typically, these are with mental health disorders. If what is occurring could be addressed if another employee did it that did not have a disability, you can address that conduct, but it's very important to keep records in those situations about the reasons you did address the conduct so it doesn't appear as retaliation for somebody engaging with the ADA process. The Age Discrimination in Employment Act passed in 1967, and it prohibits treating an applicant or employee less favorably because of their age. This doesn't apply to different treatment for any age, only those 40 years of age or older. This law, like many others we have discussed, is enforced by the EEOC. To establish a case for intentional discrimination under the ADEA, the complainant must show that they are 40 or older, they suffered an adverse employment action, they're qualified for the position at issue, and they were treated less favorably than others not in the protected class. Here, age. The burden then shifts to the employer to show some other non-discriminatory reason for the adverse action taken. So the Family Medical Leave Act was a federal law signed by Bill Clinton that allows eligible employees to take up to 12 weeks of unpaid leave each year for certain family and medical reasons. This is a job protection statute, not a pay protection statute. To qualify, an employee must have been employed for at least 12 months before the leave and have worked at least 1,250 hours during the previous 12-month period. So if a lot of time was taken off for other reasons during the previous 12 months, such as a leave of absence, an employee may not qualify. The reasons leave can be taken are birth of a child, or to care for a child after birth, placement of a child for adoption or foster care, to care for a spouse, child, or parent, if such person has a serious health condition, a serious health condition of the employee themselves, or certain exigency services caused by the employee's spouse, child, or parent on covered active duty in the armed forces. Employers will usually have employees fill out paperwork which certifies that they meet a qualifying condition of the act and may ask for medical documentation as well. Intermittent leave can be an option for some conditions, so the employee will work part-time and take part-time leave. When the employee returns from leave, the employer must place them in the same or an equivalent position when they return if employee is able to perform the essential job functions. We'll talk a little bit more about that on the next slide. Basically, your employer is not allowed to permanently replace you if you take FMLA leave. The employee will retain all of their same employee benefits while on leave, such as insurance, although pay while on leave is not guaranteed. The employer is allowed to require the employee to report periodically on their status and their intention to return to work. There is a certain amount of overlap between ADA and FMLA because, as you can imagine, some reasons a person might go out on FMLA leave may result in a disability when they return. There's some disagreement on whether additional leave beyond the 12 weeks allowed by FMLA is a permissible accommodation under the ADA. Generally, the answer is yes, but the disagreement largely centers on the length of that leave and if there is, some sort of endpoint to that. Another area of overlap between these two laws is how employers keep the medical records of an employee. So these records are not protected by HIPAA since there's not a treating relationship between the employer and the employee, but the employer is required to keep these records in a separate file and to keep them confidential. An employee also has a cause of action against an employer if they are retaliated against for trying to use FMLA leave or pursuing an accommodation through ADA and then suffer an adverse employment action for doing so. So here's the last federal law we're going to be discussing today. It's also the newest. The Pregnant Workers Fairness Act went into effect on June 18th, 2024. This act requires employers to accommodate pregnant workers. So this does not apply to discrimination against pregnant workers. This only applies to accommodating pregnant workers. Discrimination against pregnant workers can be addressed under other laws we've already discussed, like Title VII, Title IX, ADA, and FMLA. ADA does not consider pregnancy a disability like we've discussed. So what this law does is require employers to accommodate a pregnant worker's known limitations due to their pregnancy, childbirth, or a related medical condition. Like the ADA, employers are not required to implement accommodations that will cause the employer an undue hardship. Here's the general list of what employers are not allowed to do under the Pregnant Workers Fairness Act. So they cannot fail to make a reasonable accommodation for the known limitations of an employee, unless those accommodations would cause an undue hardship, which, like we've said, is a pretty high burden. You can't require an employee to accept an accommodation other than a reasonable accommodation arrived at through the interactive process. You can't deny a job or other employment opportunity to a qualified employee based on their need for a reasonable accommodation. You can't require the employee to take leave if there is another reasonable option. You can't punish or retaliate against an employee for requesting to use a reasonable accommodation. This accommodations process is similar to the ADA, but it doesn't necessarily need to be as formal. So for the Pregnant Workers Fairness Act, you cannot require medical documentation if the need for an accommodation is obvious. One example given is if a pregnant worker requests a larger uniform. Leave can be a reasonable accommodation, but employer cannot force leave if a different reasonable accommodation is available, and the employer does not have to provide leave as an accommodation if it causes an undue hardship. So that was quite a bit of information. And now we're just going to briefly touch on how this kind of affects the learning and working environment in other ways. First up is accreditation. So accreditation is basically a formal independent verification that a program or institution meets established quality standards and is competent to carry out specific tasks. So basically, if you meet the standards set by an accreditor, you're qualified to do X thing or whatever that accreditor accredits. You're agreeing to be held by a certain set of standards for a particular purpose. Accreditation requirements are not set by law. but they cannot violate established or passed law. The law will always take precedence over accreditation standards, but they are permitted to impose additional requirements on the accredited party. Accreditation can be required to participate in certain federal programs. So I've listed some common accreditors that we see in healthcare, GME, and higher education. Most GME programs in the United States are accredited by the Accreditation Council for Graduate Medical Education. The ACGME accredits sponsoring institutions, which then have sponsored programs accredited beneath them and under their sponsorship. Here's one example from the ACGME institutional sponsor requirements that shows how accreditation can affect the work environment. Under this standard, the sponsor has to be, one, in substantial compliance with the ACGME institutional requirements itself, and two, must also ensure that all of its programs comply with a whole host of other requirements listed there. So as a specific example, let's take the standard for vacation and leaves of absences. The ACGME institutional sponsor requirements require the residents to be provided with a minimum of 6 weeks of approved medical leave starting the day the resident is required to report, and that the 6 weeks of leave will be paid. Think back to what we just learned about FMLA. It guarantees 12 weeks of unpaid leave after the employee has been working for 12 months. Here, the requirements between the accreditation standard and the law are different, but they don't necessarily conflict with each other. Therefore, the accredited parties need to follow both sets of requirements. The employer would still be required to give 12 weeks of leave to those employees that qualify under FMLA, but only the first 6 weeks must be paid. Likewise, even if an employee hasn't been employed a full 12 months yet and wouldn't qualify for FMLA, to comply with the accreditation standard, they must give the employee 6 weeks of paid leave. Going even further, the ACGME Common Program requirements add another layer. So these are the requirements applicable to all sponsored programs. In this example, there are some other requirements that go along with our leave example. If a resident is out on caretaker leave, for example, the program needs to have policies in place to ensure continuity of patient care. Again, this doesn't conflict with FMLA, but it adds another layer of detail in the workplace environment for how these things will be implemented. And so notice that this specifically imposes an obligation to implement policies. So lastly, I want us to take just a quick look at how the policies are implemented that kind of put all of this into action. Policies kind of stack on top of legal and accreditation requirements. They're often drafted in a way intended to fulfill legal or other responsibilities and give instructions on how to do so. They give more detail and process than legal requirements or accreditation requirements. I've linked the GME website here with the GMEC policies. I chose these just because I know we all have access to them. If you did this with any workplace policy, it would be the same. And if you go take a look at the parental, medical, and caretaker leave of absence policy, you'll see some specific references. Scroll down. You'll see specific references to some of the things we talk about. You know, they'll have language that was from the ACGME standard. You will see, you know, specific reference to FMLA. So you'll kind of get the gist of how policies are crafted, what they're intended to enforce. Many policies will have the specific requirements listed kind of for the reasons why we have it in the first place. So this is just one example, but many policies, you know, have the same formula. So that's my presentation. Thank you for sticking with us through our technical difficulties. Does anybody have any questions?
Looks like there are no questions. So Amy, thank you so much for joining us today and presenting on all of these topics. We appreciate you and look forward to having you present again.
Thank you.
Thank you.